He's here, got it. Mr. Smith?
Good afternoon, Your Honor.
Good afternoon, Happy New Year.
Well,
Let's see. Faye Brown failed to appear. This was a show cause, so you can have a bench warrant.
okay, we'll submit as far as bond, Your Honor, for consideration, bond consideration purposes, balance $9,820.04.
10%.
All right, we will prepare and submit that.
Thank you.
You bet.
Okay, let's see. Mr. Cradaville?
Yes, Your Honor.
Okay, good afternoon, that is. Let's see. No one's appeared for Natalia Brown on her motion.
Okay.
Let me see here. I'll call this case. Let's see. RPM Auto Sales versus Natalia Brown, 18-02410 GCE. Counsel, could I have your appearance?
Good afternoon, Your Honor. Brent Cradable, P75845, appearing on behalf of plaintiff RPM Auto Sales.
Okay, thank you. And Mr. Credible, today was the date that was set for a motion. I have a notice of hearing a motion filed by Ms. Brown. She indicated that she wanted to dismiss the judgment, indicating that it was paid in full, that her taxes of $10,000 was garnished in 2019. Is that accurate?
It's not, Your Honor. I have a feeling I know what happened, but obviously without her here, it's hard to have that discussion. Those notices from the state of Michigan regarding, income tax refunds being garnished, it's kind of confusing to look at. You don't look at them all the time. There's two numbers, one of which is the judgment balance on the date that the garnishment was filed. The other amount is the amount actually being garnished. I have people calling my office all the time to tell me, oh, you took the full judgment balance, this year, and they're just looking at the document wrong, frankly, because it's confusing. I'm guessing that's what happened here, but no, we only received $192 from that tax garnishment. We've received a few other payments. We've received a total of $380.43 on this file. The total balance at this point with interest accruing is over $16,000.
Okay, I'll note that here in the file. Obviously, her motion will be dismissed because she failed to appear, but I wanted to get your response on the record in case she appeared later or tried to refile her motion. So you're all set. Her motion is denied.
All right. Thank you, Your Honor. Have a good weekend.
Thank you. Same to you. On the record in the matter of Lafque versus Jacob Burt, file number 22-01078, counsel appearance.
For plaintiff Lafque, Tim Smith, P48259.
Okay, I see Jacob Burt is present via Zoom. Mr. Burt, can you unmute yourself?
Yes, Your Honor.
Okay, very good. Today was the date and the time that was set for a motion to show cause. I do believe the parties did meet. Mr. Smith, did you get the documents you needed or did you need another date?
I didn't get them, Your Honor. This dates back to September 15th at the original examination. Following that examination, he was sent a letter specifically reminding him what he needed to produce and where to mail those same documents. The documents included 6 months of bank statements from two different institutions, MetaBank and Cash App, as well as his taxes from last year. We've been back in front of you since then. As I sit here right now, I do not have the documents. Now, we wanted to break our own. Mr. Burt explained that he has the documents in hand and promises to mail them. So perhaps rather than a contempt proceeding this afternoon on the motion to show cause for failing to produce those documents, perhaps we would give him 14 days to get them into my hands. If I don't have them within 14, I can simply file a bench warrant.
Okay, and Mr. Burt, you do understand that this is under court order, that you are to provide these documents?
Yes, Your Honor. So he was asking for 3 documents. One out of the 3, I unfortunately do not have access to anymore. The account has been deactivated. That bank account I haven't used or had any kind of access, or excuse me, any kind of purchases or anything like that for over a year. So when he asked for those, I was trying to log in and everything, and I was notified it was deactivated. So that account no longer exists. But I do have 2 out of the 3 documents physically, literally a foot next to me, and I did fail to mail them in, unfortunately.
Okay, so you're gonna get those over to Mr. Smith within the next 14 days, correct?
Yes, Your Honor.
Okay, I'm gonna go ahead and set this for a control date just to ensure that Mr. Smith has received these documents. Mr. Smith, you can notify the court if you no longer need that date. Mr. Burt, if he does not receive those documents, then he will be requesting a bench warrant. You're also subject to a contempt of court order proceeding. A contempt of court can be penalized with a fine or jail time. So I don't think you want to do that when you could just turn over the documents, right?
Yes, Your Honor.
Okay, and so I think we'll just get your next date and then you'll get that off, and then we'll be able to move forward in this matter.
Thank you both so much.
Let me see our next available date. For whenever we're ready. 2 weeks. Yeah, that's fine. Next available date. It's gonna be more than 50 days, I'm sure. February 2nd. Our next date is February 2nd at 1:30.
All right, thank you, Your Honor. Appreciate the help.
Thank you. You're all set, Mr. Burt.
Thank you so much.
Let's see. I did that one already. On the record in the matter of T&T Financial versus Melinda Milton, file number 22-02560. Council appearance.
Good afternoon, Your Honor. James Meineke appearing on behalf of the plaintiff T&T Financial.
Okay, thank you, Mr. Meineke. Today was the date set for a hearing on an objection to income garnishment of income tax. The matter was set for hearing today at 1:30. It's 2:07. We've not seen Melinda Milton. So her motion will be denied.
Thank you, Your
Her
Honor.
objections will be denied. Let's see here. Okay, we'll provide an order of reflecting the garnishment being, objections being denied. Any additional matters for the record?
Nothing further today, Judge. Thank you.
Thank you. Have a good one.
You take care.
Okay, let's see. Is Timothy Roper present? It's not yet. I don't see a Crystal Manor present yet. Anybody here present on her behalf?
I mean, yes, Your Honor. Mr. Kent Wood, I'm hearing on.
Okay,
And Mr. Lovejoy's with me in my office. He was having some technical issues at his office, so he came over here for our pretrial.
okay, so you're both from the same office. Wonderful, because all you need to do is complete a joint pretrial statement and file it with the court.
Okay. I'll check. We have a joint pretrial statement. I'll see. I'll make sure if it hasn't been sent to you, I'll make sure it gets sent to you right now, Judge. Thank you.
Okay, yep, actually it needs to be filed on my file.
Yes. Okay.
So other than that, if we'll, once we get that, we'll send our next scheduling dates.
Okay.
From that. You're all set. Thank you.
Thank you.
Okay, and Mr. Chernick is here, and then let's see who's here. Christine Richter here on behalf of Portfolio.
Yes, good afternoon, Judge.
Good afternoon. Let's see, did you come to any resolutions or complete a joint pretrial statement yet?
No, Your Honor, parties had a chance to speak and there is a disagreement on the scope of discovery. So I think that's why we had to appear today.
Okay, sounds good. I'll call the case. On the record in the matter of Portfolio Recovery versus Marissa and Zoldia, file number 23-02434 GC appears for the record.
Good afternoon, Your Honor. Christine Richter for the plaintiff, P61525.
Good afternoon, Your Honor. Scott Chernich on behalf of Marissa Enzaldua.
Okay, very good. Today was the date and time set for pre-trial. A general civil matter, and so you all were working through your pre-trial statement and the issue of the scope of discovery came up.
Yes, Your Honor. The understanding that I have is Mr. Chernich wishes to depose a custodian of records of my client. I'm objecting to a deposition based on MCR 2.302B. This is a $2,166 credit card case where counsel has already been provided a full transaction history from the inception of the credit account through its charge-off. Under the factors to be considered under the court rule, I believe the burden and expense of a deposition outweighs the likely benefit, considering that I've already provided counsel all of the relevant documentation that my client would have relied upon in executing the affidavit that Mr. Chernich wants to impeach. Also, the complexity of the case, Your Honor, again, this is a very straightforward credit card transaction issue here. My client purchased the account from Synchrony Bank. This was a care credit account, and there were simply two charges on the account, both from one dentist's office. It's a very straightforward account. It accounts for all interest and fees down to the penny throughout the life of the account until charge off. There's nothing more to be gained from a deposition here. Also, the amount in controversy, $2,166. That doesn't, in my opinion, justify the time and expense of a deposition. Also, one of the issues that Mr. Chernich was looking for was signed transactional receipts from the credit transactions, which I submit to the court. He can, or his client can, obtain those directly from his dentist's office when the credit transactions occurred.
Mr. Chernich?
Thank you, Your Honor. Well, up to this point, what I've gotten from opposing counsel has been somewhat of a mess. It's hard to discern what's occurring in these documents. The first tranche of documents I received came in that were impossible to read. In reviewing the affidavit, this is the sole document that's attached to this pleading and the complaint. In that document, this person that signed this affidavit on behalf of the plaintiff makes a lot of representations. I think it's fair that we take this the deposition of this record keeper to find out exactly what happened in this case. And so unless and until we do that, I really can't discern what's going on. And quite frankly, to turn the tables on us to say, oh, by the way, you should go to your dentist to find out what the charges were for, really turns the tables on who bears the responsibility here to prove its case. And it may be expensive in the plaintiff's mind, but when they take on these matters and decide to buy accounts and then attempt to recover on them and file suit, they can only expect that we're going to ask questions. So I think it's entirely necessary that we take the deposition of the record keeper, Ms. Erica Turner.
Okay, so you have received information, but you said it's not clear or legible. Is that accurate?
The first tranche of them that I got is very confusing and impossible to read. After that first set of documents, we did get some other documents that appear to be statements that are very difficult for me to reconcile and for my client to reconcile.
Your Honor, these are run-of-the-mill credit card statements. The very first credit card statement shows 2 purchases, the exact date of those purchases, and the exact amount of those purchases. Every single credit card statement breaks down every cent of interest that accrued and fees that accrued. And there were 0 payments on the account. It's a very, very basic transaction history. And I think it's disingenuous for Mr. Chernich to say he can't make heads or tails of these credit card statements. Perhaps he doesn't understand the sale documents, but I don't even believe the ownership of the account is at issue here. Essentially what he stated to me is he wants to prove that my client is a robo-signer. He wants to blow a bunch of smoke in the air and make my client look like a bad actor because they're a debt collector. But the bottom line is, Your Honor, this is a credit card case, and the law in Michigan doesn't require me to provide more than the credit card statements and proof that my client purchased the account. I have provided him 100% transactional history from start to finish. On a $2,000 claim, he doesn't need more than that. And I submit to the court that he's only doing this to harass my client and create unnecessary time and expense that isn't necessary.
Your Honor, if I could respond to that. I don't want this to be more than it is, but I'm going to tell you that we tried on numerous occasions to get documents from this plaintiff. And what we got was stonewalling, refusal to cooperate, essentially documents and responses that said, just go jump in a lake. We don't have what you want. And then the first set of documents I get are completely unreadable. They make no sense whatsoever. I do get documents afterwards, and it's hard to reconcile what they sent me in the first tranche of documents to the second. Then I asked for the documents to demonstrate my client signed anything that would incur debt on her behalf with whomever it is that they represent, who I can't really tell at this point. And then the response is, oh, go talk to the dentist. Well, they're the ones that sued my client. They have the responsibility to prove that the debt exists. They bought this debt in a big debt sale, and then they make representations in the affidavit. And I think it's fair to ask them what these representations and the representations they make to this court are accurate.
Okay, so my concern, I think, is twofold. First, the request for documents, I don't see how that's unreasonable for them to request the documents they need from the person that's suing them. You can't redirect them or reroute them to someone else if that's a document that you have access to. If you don't have access to it, then that's different.
Your Honor, my client does not have access to that. What I'm trying to tell the court is I have a credit card statement showing 2 purchases for a set amount. What he's saying is he wants the underlying receipt from when the charge account was used at the dentist's office and when his client may have signed a receipt for those credit card charges.
I
I don't
understand
have
that
them.
much. Yeah, agreed. And in a formalized discovery or request for production of documents, that would suffice it enough to indicate that those are documents that are within your possession or control. And so we can't order her to go and find those documents on your behalf. Discovery periods don't just mean that you have the opportunity to seek all the information from the person that's suing them. You may have to get things that support your defense from other parties, and that may have to have happened by way of a subpoena. You may have to subpoena those records from whoever has them if this entity does not have them. As it relates to a deposition, this to me, from the very little information that I have here in this file, it seems like a very standard run-of-the-mill breach of contract case involving a credit card or credit card transactions. There's absolutely no way I think it's reasonable that we should hold depositions for $2,206.74. The defensive or ordering and defending a deposition is a costly expense. I don't think that it's meaningful. I don't think it's going to help flush out whatever documents that you have. I think that if we have 2 professionals here, as you all presented yourself to be, if you have questions about what those documents are, I don't see why Ms. Richter's are not able to explain what those documents are, because if they're transaction histories, they can't be, I don't know what a deposition of the keeper of records would do to help further explain those things. I think that just includes more expense. It also complicates a very simple district court issue. And so I'm not going to grant a request for a deposition in this matter. Obviously, you all have the right to request documents from each other. To the extent that the plaintiff has the custody of those documents, they need to turn them over unless they have a valid objection as to why they shouldn't be turned over. And one of those objections could be they don't have that document or those documents in their custody or control. So outside of that, I think that you all should be able to complete your joint pretrial statement.
I'm happy to do so.
Thank you, Your Honor.
Okay, I can either put you in a private meeting room or do it now. You can obviously do it outside of the court's time. We just need it to be filed with the court through my file, and I should expect that file within the next 7 days.
Your Honor, I would hope that we could crank it out in a breakout room.
Okay, I'll put you in a private meeting room now.
Thank you, Judge.
There's something here because I don't see, did I miss a case? Okay. I just did this one. No, I didn't. There was only 3 or 2. Roper never appeared, correct? Right.
Good afternoon, Your Honor. Ronald Buck. I'm hearing for John Hintz today for that Esker versus Roper matter.
Okay, he's failed to appear. We can set it for show cause.
Sounds good. I'll have our office prepare one. Thank you.
Thank you. You're all set.
Have a good day.
You too. 7-2. That's what it was.
It was quite wild.
It was.
Really.
Were you able to work out your pretrial statement?
Your Honor, we realized in the breakout room, neither of us actually received the standard form. We actually had some potential settlement discussions, and so we decided if the court would allow, we can just either try and work out a resolution or submit the pretrial statement within the next 7 days.
That sounds good. Did you need us to email you the standard form?
If you could, that would be wonderful.
What, do you have her email?
No, I don't.
Okay, can I have your email?
Sure, it's, I'm gonna spell it out just because it's my full name and it's spelled a little weird. It's Christine, which is CHRISTENE .Richter, which is RICHTER at portfoliorecovery.com.
Okay, sounds good. So I'll note here that we'll expect either a joint pretrial statement or some kind of resolution within the next 7 days to be filed through in my file, that is.
Sounds great.
I'm sorry.
Thanks, Judge.
Thank you. You're all set.
Thank you. Have a great day, Judge. Thank you, Mr.
You
Chernich.
too.
Yep, thank you.